If you own a home and you are over 60, there are 3 documents that could be the difference between your family keeping everything you built and losing a significant part of it to a process most people never see coming until it is too late. By the end of this video, you will know exactly what those 3 documents are, why most homeowners over 60 have never filed them, and the one among them that has the smallest window to act on before the option disappears entirely. Stay with me, because the 3rd document on this list is the one almost nobody talks about until a family is already sitting in a courtroom watching a judge decide what happens to their parents' home. Before we get into it, I want to be upfront about something. Everything you are about to hear is built around general legal patterns and widely documented estate planning practices shared here for educational purposes only. Nothing in this video replaces advice from a qualified estate attorney in your state, and I will say that again before we are done. The rules vary by state, costs vary by county, and your specific situation matters. What I can give you today is the framework, so that when you do sit down with a professional, you already know what questions to ask. Here is why this matters right now and not next year. Every one of these 3 documents has something in common. Each one has to be filed while you are still healthy, still mentally competent, and still in full control of your decisions. The moment a health event happens, a hospitalization, a diagnosis, a fall, the window on at least one of these closes permanently, not figuratively, legally, and by the time most families find that out, the only path left runs straight through a courtroom. That is what we are going to walk through today. 3 documents, why each one exists, what happens without it, and what you can do this week to get started. And before we dive in, a quick note. If this is the kind of information you find useful, helps this reach other homeowners who could use it. And subscribing means you will be here for the rest of these walkthroughs. Now let's get into it. Let's start with something most people never think about when they buy a home. The moment you sign those papers and your name goes on that deed, a clock starts running. Not on your mortgage, not on your property taxes, but on something much quieter. A legal process that has been sitting in the background of American property law for over 200 years, waiting for the day you are no longer here to manage things yourself. That process is called probate. And before we get into the 3 documents, I want to spend a moment explaining what it actually is, because most people have heard the word without understanding what it means in practice. Probate is the legal process by which a court takes control of your estate after you die, verifies your debts, and supervises the transfer of your property to whoever is supposed to receive it. It sounds orderly. It sounds protective. But here is what it looks like from the inside when a family goes through it unprepared. The house cannot be sold. It cannot be refinanced. In many cases, it cannot even be fully accessed for repairs or management while the process is ongoing. Property taxes keep coming due. Insurance has to stay current. If there is a mortgage, those payments do not pause. All of that falls on your family while they wait for a court to give them permission to touch what you spent your life building. The average probate case in the United States takes between 9 months and 2 years to resolve. The average cost runs between 3 and 8% of the total estate value. On a home worth $300,000, that is somewhere between $9,000 and $24,000 paid to courts, attorneys, and administrators before your family sees a single dollar. And that number does not include the carrying costs of the property during that waiting period. My name is Michael Carter. I spent more than 20 years working as a banking security consultant, which meant watching very closely how families lose money, not just to scams and fraud, but to systems that were never designed with their interests in mind. Probate is one of those systems, and that is part of why I put together something called the Retirement Defense Kit, a practical resource designed to help retirees protect the money and the assets they spent a lifetime building. I will share more about that in a moment, but first let us talk about the 3 documents that can change this picture entirely. The first document is called a Transfer on Death Deed, and it is the simplest of the 3. A Transfer on Death Deed does exactly one thing. It tells your county recorder who inherits your home the moment you die, without that home ever passing through probate court. There is no court involvement. There is no waiting period. There are no attorney fees attached to the transfer itself. Your named beneficiary simply presents the death certificate, and the title moves directly to them. The filing fee in most counties is between $20 and $60. In many states, the form itself is available directly from the county recorder's office or online. It takes 1 afternoon to complete. Here is what most people do not know. This document is currently available in roughly 30 states. If your state is among them, you can file this document this week for less than the cost of a dinner out, and it will do more to protect your home from probate than almost any other single step you could take. Now here is the part worth sitting with. If this document exists, costs almost nothing, and takes 1 afternoon to file, why do so many homeowners over 60 not have one? The answer is simple. Nobody told them it existed. The probate system generates significant revenue for the courts and the legal professionals who work within it. There is no financial incentive for that system to advertise the tools that bypass it. So most people find out about the transfer on death deed the same way families always find out about things like this. Too late, sitting across from an attorney, being told what it would have cost to file it when there was still time. The second document is a revocable living trust. And this is where the protection becomes significantly more powerful. A living trust is a legal arrangement in which you transfer ownership of your home and other assets into a trust that you control entirely during your lifetime. You can sell the home, refinance it, move out of it, change the terms of the trust at any time. Nothing about how you live changes, but because the home is technically owned by the trust rather than by you personally, it does not become part of your estate when you die, which means probate court has no jurisdiction over it. On a home worth $400,000, moving it into a living trust could save your family between $12,000 and $32,000 in probate costs alone. But the financial savings are only part of what a trust does. A trust gives you something a will cannot: specific, private, legally binding instructions for exactly what happens to your home after you are gone. If you want your surviving spouse to remain in the home for the rest of their life before it passes to your children, a trust can do that. If you have multiple children and want to prevent a situation where one wants to sell and another wants to keep the property, a trust can address that directly. If you want to protect the home from being affected by a future divorce or legal judgment against one of your children, a trust can do that too. A will gets read in a courtroom, interpreted by a judge, and becomes a public document. A trust is private. It bypasses the court entirely and does exactly what you wrote into it. Setting up a living trust typically costs between $1,500 and $3,000 through an estate attorney. Some people see that number and decide to wait. I understand the instinct, but I want to offer a different way to look at it. On a $300,000 home, the cost of setting up a trust is roughly 0.5% of what you are protecting. And unlike probate fees, which come out of your estate after you are gone and cannot be undone, this is a one-time cost paid while you are still here and in control. There is one critical step that goes with setting up a trust that I want to mention specifically because it is where a significant number of families make an expensive mistake. Creating the trust is only half of the process. The other half is called funding the trust, which means actually transferring the deed of your home into the name of the trust. If the trust exists on paper but the deed was never updated, the trust does nothing. The home still goes through probate, exactly as if the trust had never been created. Every dollar spent setting it up is wasted. So if you already have a living trust or decide to create one, the very next step is confirming with your attorney that the deed to your home has been retitled in the name of the trust. Now we are at the third document. This is the one I mentioned at the beginning, the one with the smallest window and the most severe consequences if you wait too long. It is called a durable power of attorney for finances. This document names a person you trust to manage your financial affairs if you become unable to do so yourself, not after you die, while you are still alive but incapacitated. A stroke, a serious fall, a diagnosis that affects your ability to make decisions. These are not distant possibilities for people over 60. They are the kinds of events that happen to real families every single year, often without warning, without a durable power of attorney in place. Here is what your family faces. They cannot legally access your bank accounts. They cannot pay your mortgage. They cannot manage your property taxes or your insurance. They cannot make any financial decisions on your behalf, regardless of how clearly you would have wanted them to. To get that authority, they have to go to court and ask a judge to appoint a legal guardian or conservator over your financial affairs. That process is called a guardianship or conservatorship proceeding. It typically takes between 3 and 6 months to complete. Legal fees often run between $3,000 and $10,000 just to obtain the appointment. And after that, the appointed guardian is usually required to file annual reports with the court, which adds ongoing costs year after year. During those months of waiting, nobody can pay your mortgage. Nobody can handle your property taxes. Nobody can sell the home if that becomes necessary for your care. Families lose homes to foreclosure during guardianship proceedings every year in this country, not because of anything complicated, but simply because the legal authority to act was not in place when it was needed. A durable power of attorney costs between $100 and $300 to draft with an attorney. It takes about an hour to complete, but here is the part that makes this the most time-sensitive document on this list. It must be signed while you are still legally competent to sign it. The moment a physician questions your mental capacity, the option to sign one closes permanently. You cannot sign it from a hospital bed after a stroke. Your children cannot sign it on your behalf. Once that moment passes, the only available path is the courtroom. I think about a retired couple I worked with years ago. I will call them Richard and Carol. Richard had handled all of their finances for decades. Carol managed the home. They had a will. They owned their home outright, and they assumed that was enough. And then Richard had a stroke at 68. Suddenly, Carol needed to access accounts, manage insurance, handle property taxes, all in Richard's name, and she had no legal authority to do any of it. The guardianship process took 5 months and cost the family just over $8,000 in legal fees, all while Carol was managing Richard's care and trying to hold everything else together on her own. Richard recovered, but Carol told me afterward that the hardest part was not the money. It was that all of it could have been handled in a single afternoon, months earlier, for a fraction of what they ended up paying if they had only known the document existed. That is exactly the situation this channel exists to help you avoid. The system was not built to make this easy to figure out on your own, but now you know, and that changes what you can do about it. That is also exactly why I put together the Retirement Defense Kit. After years of watching how families lose money, not just to scams and fraud, but to legal systems they never had a chance to prepare for, I wanted to create something practical, a resource that helps retirees stay informed, stay independent, and protect what they have worked their entire lives to build. If you would like to learn more, the link is in the description below this video. So, to bring the 3 documents together, the transfer on death deed handles the transfer of your home after death quickly and without court involvement, and is available in roughly 30 states for under $60. The Revocable Living Trust protects your entire estate from probate, gives your family specific private instructions, and offers a level of control that no will can match. And the Durable Power of Attorney for Finances protects your family during your lifetime in the event you become unable to manage things yourself, and has a window that closes the moment your legal competence is in question. Each of these documents has to be in place before you need it. That is the part the system counts on you not knowing until it's too late. There is one more thing worth addressing before we move on, because it comes up often and it matters. Some people watch a video like this, feel the urgency, and then spend the next few days paralyzed trying to figure out which document to start with, how to find the right attorney, whether their state allows a transfer on death deed, what a trust actually costs in their county. The thinking becomes so complicated that nothing happens. So here is the simplest version of what to do this week. First, find out whether your state offers a transfer on death deed. You can do this by searching the words transfer on death deed followed by the name of your state. If it does, call your county recorder's office and ask how to file one. That is your starting point, because it is the fastest, least expensive action on this list, and it removes the most immediate risk. Second, write down which of the 3 documents you already have in place: a transfer on death deed, a revocable living trust, a durable power of attorney for finances. Be honest with yourself. If you are not sure, that is your answer. Third, call an estate attorney in your county and ask for a consultation specifically about these 3 documents. Most attorneys offer an initial consultation for between $100 and $300. Bring your list. Tell them which ones you have and which ones you are missing. Let them tell you what your state requires and what the costs look like for your specific situation. That is 3 steps. None of them require you to make a final decision today, but all 3 of them move you from not knowing to knowing, and that is exactly where the protection starts. The system that profits from families not having these documents in place is not going to send you a reminder. It is not designed to, but you now have the information, and the next step belongs entirely to you. Now, one thing I want to be clear about before we wrap this section. None of these documents are permanent in the sense that filing them once means you never have to think about them again. Life changes, and your documents need to reflect that. If you get married or divorced, if a beneficiary passes away before you do, if you move to a different state, if the value of your estate changes significantly, any of those events is a reason to review what you have in place. An estate attorney can help you build a simple review schedule. Most recommend looking at your documents every 3 to 5 years or after any major life event. The goal is not a perfect plan filed once and forgotten. The goal is a living, updated set of protections that reflects where you actually are right now. Because at the end of the day, that is what all 3 of these documents share. They are not complicated. They are not expensive relative to what they protect. They are simply information that the system was never motivated to share with you, and that most families only discover when the window has already closed. That is what this channel is here to change. So here is what I want you to do before this video ends. And I mean today, not this weekend, not when things calm down a little. Open your phone or your computer and search 2 words. Transfer on death deed, followed by the name of your state. That search takes 30 seconds. The result will tell you immediately whether that option is available where you live. If it is, you now have a starting point that costs under $60 and can be completed this week. If your state is not on the list, that tells you something too. It means the living trust becomes your most important next step, and a single conversation with an estate attorney in your county will tell you exactly what that looks like for your situation. That one search, 30 seconds, is the line between knowing and not knowing, and knowing is where everything else starts. I think about Richard and Carol often, not because their story ended badly. Richard recovered, and Carol eventually got everything sorted, but because of the 5 months in between. 5 months of Carol managing her husband's care, fighting through a legal process she never expected, paying fees that should never have been necessary, all because one document had never been signed. One afternoon, that never happened. You have that afternoon available to you right now. That is the part I want you to hold on to after this video ends. The 3 documents we talked about today are not complicated. They are not reserved for wealthy families or people with expensive attorneys on retainer. They are tools that exist specifically to protect people like you, homeowners who worked for decades to build something real, from a system that was never designed to make things easy for the people going through it. The transfer on death deed, the revocable living trust, the durable power of attorney for finances, 3 documents, 1 afternoon each, and the kind of protection that most families only wish they had thought about sooner. Do that search today. Write down what you have and what you are missing. And if you found this useful, share it with someone you know who owns a home and is over 60. because the best thing about information like this is that it works just as well for the people you care about as it does for you. Take care of yourselves, and I will see you in the next one.